Very pleased to say we've got a guest from the other side of the globe with us, Sally Foskett from the Australian ACCC. Sally is Executive Director of Data Strategy, leading the Strategic Data Analysis Unit at the ACCC. She's going to give us a presentation on how to analyze algorithms, use compulsory information gathering powers, and machine learning, all in the context of the Trivago case. Over to you, Sally. Thanks.
Great, thank you very much, and thank you so much to the CMA for inviting us to come and participate in the conference yesterday and today. I've learned so much, and I'm looking forward to learning so much more, so thank you very much. Today, I'm going to be talking about, if I can get my slides up, there we go, no we don't, there we go. Today I'm going to be talking about how we analyse algorithms at the ACCC, and I'm going to talk about this in a general sense and cover off on some key concepts that are involved in thinking about analysing algorithms before diving into a bit of a case study in relation to the ACCC's recent case against Trivago for misleading and deceptive conduct. And I've called the talk today Algorithms and Acronyms. You might be wondering why. Look, the reason is, as a public servant, I am prone to using lots of acronyms like ACCC, and as a data scientist, I'm also prone to using lots of acronyms as well. So there will be some acronyms throughout the talk today, but hopefully you'll bear with me. So stepping back a little bit, I thought it would be useful to talk about why algorithms are relevant to competition and consumer protection authorities. And the answer is algorithms are increasingly used to implement, and some would argue, make decisions across the economy. Decisions like which products to display to consumers, in what order and for how much. Decisions that have trade-offs for product safety, for example, the classic trolley problem about which set of pedestrians the self-driving vehicle should run into, and decisions about how to participate in a market vis-a-vis competitors, for example, how to price products or how to distribute goods across the supply chain. And because algorithms are used to implement, maybe make decisions across the economy, it's really important that competition and consumer regulators have the ability and the will and the courage to obtain and analyse those algorithms and their implications for competition and consumers. So how do we do this? Well, at their simplest, an algorithm is a set of rules that process an input into an output. And the rule can be really, really simple, like divide by 2, or the rule can be very, very complex, and we can have really complex systems that we might refer to as the algorithm. So a point to make here is that when working on a particular case, when we talk about the algorithm, it's really important to be specific about whether we're talking about the entire system or whether we're talking about a component of the system. And when we are looking at a big system, it's useful to remember that it often is comprised of several parts, so we can kind of break down the problem into looking at those component parts. Now, the rules that comprise an algorithm are written in a programming language like Python or Java or C++, and that code is stored in one or more files. And just like we can, as regulators, analyse Word documents or Excel spreadsheets, we can also obtain Python files or Java files and have a look at them and read them and see what they say. Like many authorities, the ACCC has the ability to compel firms to produce documents or furnish information that's potentially relevant to a breach of the Competition Consumer Act. So in this context, producing documents relates to things that already probably exist, like source code files, and furnishing information is really about asking firms to collate information in response to a specific question. On the screen here, I've got an example of what source code looks like. Probably many of you have seen code before, but if you haven't, this is it. I've pulled this example off of the internet. It is not Trivago's code. I don't know much about what this code is doing. It was just kind of a random example. But looking at it, I can tell you, well, it's written in Python. It looks like the beginning of a function called backward. And based on the comments, this has probably got something to do with backpropagation, which is part of a process of training a machine learning model. So just like when you look as an investigator at an email and you can say, well, this is from this party to this party on this date relating to this subject, somebody with some experience looking at code can look at code and pull out some features of it fairly quickly. So we use Section 155 of the Competition and Consumer Act to obtain source code from firms where we think it's relevant to getting to the bottom of a competition or consumer issue. And we also use that section sometimes to ask firms to produce pseudocode. I've got an example here. So pseudocode is a description of an algorithm that's written at a higher level of abstraction than the source code itself. It tends to be language agnostic, and we do find this helpful in terms of piecing together where bits of source code fit into a broader system. So that is sometimes what we ask for as well. Now, when I talk about how, well, algorithms are just rules and the rules are written in code and we can look at the code and tell you what the rules are doing, the common refrain is, well, what about machine learning? How can you possibly examine machine learning? So unlike traditional algorithms where the rules are explicitly defined by the programmer, in machine learning, the rules have been derived from data through I'm generalising here, but a process of trial and error, looking at many, many, many examples. And people often describe machine learning as this impenetrable kind of black box that we can't hope to understand. I'm using a bit of rhetoric here. It's not the case that we can't look at what machine learning models are doing, and it's not the case that there is no underpinning logic. The challenge for regulators and for people who are trying to understand how algorithms work is that the logic is just a bit different. It's too complex to kind of extract into a narrative that we can understand with our minds and explain to the court in a really coherent way. So while human reasoning tends to be linear, so when I'm explaining my reasons to you, I'm limited to using one word at a time, and I'll naturally do that in a way that has a beginning, middle, and end. Machine learning reasoning tends to be really complex and multidimensional with many different moving parts at the same time. Human reasoning tends to be deductive or abductive, so reasoning to the most likely explanation, balance of probabilities, or reasoning from the general to the specific, whereas machine learning reasoning is kind of the opposite. It's inductive, so it's extracting general rules from many, 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 many specific examples. And as part of that, I also think machine learning reasoning tends to be a little bit more probabilistic. It tends to incorporate more nuance in terms of how to make decisions about the world based on examples that it's seen before. Does that mean we can't examine machine learning models? No, it doesn't. So one thing to keep in mind is that some machine learning models are more interpretable than others. Linear logistic regression has been used in science for many decades to help understand the relationship between different variables. And even more complex machine learning model structures like neural nets, we can have a go at extracting a narrative about how they work by using model agnostic methods of interpretability. I've listed some common methods on the slide there, in part to inject some more acronyms into the talk, but also because I wanted to point out that there are multiple methods available. This is an active area of research, and the application of these methods does involve a degree of subjectivity and human reasoning to apply, as we saw in the Trivago case, actually. Another thing worth keeping in mind is that machine learning models are very much a product of human decisions. So a human has decided what training data to use to train the model. A human has decided often, although this is maybe changing, which fundamental kind of structure to use for the model to store its understanding about the world in. A human's decided which loss function to use, that is what the algorithm is trying to optimize for. A human has decided which evaluation metric to use. That is, how does the business determine whether the algorithm is achieving the business goals that it was set out to achieve? And critically as well, a human has decided where the algorithm is going to be deployed, i.e. which consumers it's going to be affecting, which markets it's going to be affecting as well. So hopefully I have convinced you that regulators should have the ability and do have the ability to dive into algorithms. I'm now going to take you through a bit of a case study, which was the ACCC's recent case against Trivago. Now, I have been very, very careful that all references to Trivago's algorithm in this talk relate to information that's already in the public domain. In particular, I've referenced the court's judgment about the algorithm, and in some of the slides you will see paragraph numbers that relate to that judgment, both so you can look it up if it's of interest, but also just to, I guess, alleviate any concerns about diving into confidentiality issues. Now, what you can see on the slide here is a still from a television advertisement that ran on several Australian networks in about 2017 that was run by Trivago. And the actor in this ad repeated the phrase that Trivago would help you find your ideal hotel for the best price. And we argued that best price, because of the context in which this phrase was delivered, was a representation to consumers that Trivago, the website, would help consumers find the cheapest price for a particular hotel room. Trivago, of course, is a multi-sided platform, so the consumer goes onto the site, runs its search for a hotel room, for example, Canary Wharf, London, June 2022, and is then presented with a series of listings of different hotel rooms. And each listing has one or more offers attached to it, so different prices for those hotel rooms offered by different advertisers. The advertisers being the hotel itself, online booking sites, or online travel agents. And if the consumer sees an offer that they like, they can click on it and are then taken to that advertiser's site where they can choose to book the room if they'd like to. When the consumer clicks on an offer, that triggers the requirement that the advertiser pay to Trivago cost per click, also known as CPC, another acronym for you. And that's basically how Trivago made most of its revenue. This is what consumers saw. This, I think, was from mid-2017 on its Australian website when they ran a search. So you can see I've put a box around a listing at the top there. And on the right-hand side of the box, we see this big green button saying View Deal. That big green button is at the bottom of a box, which is referred to as the top position. And the offer that occupies that box is called the top position offer, or TPO. And if you look closely, and you do have to look quite closely, next to the big green View Deal button, in smaller text, we can see there that there's more deals in this top instance, 22 more deals. Fast forward a few months, and there's been a change to the interface, and now instead of saying more deals 22, we've got a little bit more information. So in this example, it's more deals from 192 Australian dollars. Compared to the top position offer, in this case, of 204 Australian dollars. And the question for us was, how did Trivago's algorithm determine which offer would be the top position offer, or the TPO? So the investigation team brought in my team, the data team at the ACCC, to help them try and establish this. And I've listed on the slide here basically how we helped the team from beginning to end of the investigation. So we helped them define requests as well as compulsory information gathering notices for data, sample input and output data, as well as the source code itself. We helped the team analyse that data. We did some descriptive statistics on how different inputs were distributed according to different outputs. We went through the code line by line by line to understand what it was doing and explain to the investigation team what it was doing. And I should mention, it is really resource intensive. So I hope I'm not giving the impression that this is necessarily easy. It's not. It's time consuming and resource intensive, but it is possible. Once we had analysed the data and source code and the investigation team formed the view that there was a merit in the case, we helped them define the questions for an independent expert. Likewise, ultimately, Trivago also engaged an independent expert to whom those questions were put. Throughout the proceedings, we helped the team interpret the expert reports and the evidence that they gave, both for the hearing on liability and then down the track also on hearing on penalty as well. These are the questions that we put to the computer science experts, duly with some paragraph references there. I won't go through all of them because I don't actually need to. I'm just going to go through a few of them. So firstly, how the top position algorithm operates. Again, this is in the judgment. The experts agreed that the algorithm took into account a number of raw inputs that I've listed on the slide there. So happily, offer price is in there. That's the price of the hotel room. And we also see a bunch of other inputs, including that CPC cost per click payment that I referenced before. Algorithm assesses those inputs in ways that I'm not going to go into detail, and then outputs a composite score. And basically, the offer with the highest composite score gets the top position for the listing. Now, the experts were asked to give an opinion on the relative importance or the weighting of the different raw inputs. And interestingly, they came up with some different results. So they applied different methods, came up with different results. One of the methods gave a result that the most influential input was the offer price, that is the price of the hotel room, followed by the cost per click payment. But using another method, which was, if I can, I guess, overly simplify this, more based on the actual data that we had and not so much theoretical values, using another method, the most influential input was the cost per click. How did they explain this apparent difference? Well, the expert that was engaged by the ACCC, Mr. Bajanov, explained it with a running race analogy. And indeed, there were many analogies used throughout the proceedings. He said, consider looking at the factors that drive running performance in a group of people, such as a 100-metre sprint. If we look at what factors determine the time in which a person can run 100 metres, like age, we might conclude a different set of factors have an influence than if we look at someone's probability of winning a race within a particular group, that is, within a particular group of people who are all the same age. And the expert that was engaged by Trivago, Professor Parks, explained this as follows. He said, there's a simple and consistent explanation for these two seemingly conflicting findings. CPC, that is the amount that the advertiser paid to Trivago upon their offer being clicked, plays the role of tiebreaker amongst offers that are similarly priced. What did the court make of this contradiction? Well, His Honour said it's not necessary to form a concluded view about which of the experts' approaches is preferable because each method addresses a different question. So where does that leave us in terms of the case? Well, if we go back to our list of questions, there were actually a couple of much simpler questions in there that ultimately were quite important in the overall outcome. So one of these questions was, how and to what extent, if any, does the top position offer algorithm filter certain offers made by advertisers? And the experts had agreed, and this was consistent with what the data team had found, offers are filtered out by a minimum cost per click. And so, in at least some cases, the cheapest offer of the hotel room did not appear on the Trivago website, and this alone was sufficient to render the representation misleading or deceptive. The other simple question that the case kind of, I think, concluded on the base of was this one: how frequently are higher priced hotel offers selected as the TPO over alternative lower priced offers? That is, how frequently were they not the cheapest offer? And the experts agreed that in about 66.8% of listings, the top position offer was a higher priced offer than the lowest in the listing. And Professor Parks, the expert engaged by Trivago, acknowledged this. He said, when it's the case that the TPO is not the cheapest offer, i.e. when it was more expensive offer, the variation that best explains that decision is the cost per click. And it kind of has to be, he said. I love this line. You don't need all of the fancy analysis that we're talking through to understand that. So even when we're dealing with a complex algorithm, even when we've got really complex methods of interpretability available to us, sometimes it's actually a simple kind of descriptive statistic that can really drive a narrative through the court. The other point I wanted to make about the Trivago case is we also used some expert from a behavioural economist, and this was contested evidence, but it was ultimately accepted by the court. I won't go into detail about this, but you can read about it in the judgment. What the expert said and what the court recognised was that a traditional economics approach assumes consumers are maximisers who gather all available information on all available options and all attributes of every option to come to a rational decision that maximises preferences. But there's extensive research showing that this rational decision-making approach is not descriptive of how most consumers make decisions. I think it's really encouraging that the court was willing to recognise this expertise, and I think it bodes well for future cases looking at different types of dark patterns on digital platforms. So the outcome of all of this was that the court found Trivago did contravene the Australian consumer law by making representations about how quickly and easily its website would help consumers identify the cheapest offer that matched their search. And fast forward, this whole process took 5 years, but by the end of 5 years, the court did make orders of penalties for 44.7 million Australian dollars, about 30 million euro. Thanks very much.
Thank you very much, Sally, and I look forward to being able to pepper my data team colleagues with questions about PLP and Lyman SHAP in future on the basis of that presentation. Some good questions again rolling in. I wanted to start with asking, I'm going to assume that the judge in this case wasn't a computer scientist themselves. How did you find the experience of translating all of this material and thinking and the technical material for the judge?
Yes, I think the experts carried a lot of weight in that regard. They did resort to analogies a lot of the time. So we saw the running race analogy. There was also an analogy about apartment prices at one point as well. But turning something technical into a story that was really relatable, I think definitely helped. And we were fortunate as well that His Honour did really engage with the material and ask questions of it. So yes, I think analogies can help. I can't recall if we did this in Trivago, but another approach we've taken is picking a single consumer in the data and kind of walking through, well, what happened to this particular consumer? So putting forward a single example can sometimes make something technical a little bit more real. Yeah.
Great, thank you. So you said analysis of the algorithms was quite resource intensive. How many staff at the ACCC have expertise with algorithms, and how many did it take for this case?
Good question. So over the course of the matter, I think we had 4 data scientists working on this case. But like all enforcement matters, it was quite lumpy, the amount of resources required. So sometimes we wouldn't do anything for 6 months while some other process was underfoot. And then we'd have someone on it full-time for a month and then off again. In terms of how many data scientists we have who can do this sort of work, I'd say it's around 5 at the moment. Really, what you need to be able to do is to solve problems and be interested in solving problems. That's the number one skill that we look for. And then knowing one programming language is a requirement. As long as people know one, with the help of Stack Overflow, they can kind of work through other languages as well.
You mentioned the difference between overall systems of algorithms and individual components. Mm-hmm. Were there any issues in the Trivago case with identifying the right component to look at? And does the interaction between the different components make the analysis more difficult?
I might answer this one in the general rather than speaking specifically about the Trivago case. So sometimes we've found that the most interesting bits of the algorithm weren't the bits we were necessarily looking for. Sometimes we think we know what where the potential area of misleading deceptive conduct, if it's a consumer case, is, and we have on occasion actually found sometimes bugs in the code that have led to something that was represented to consumers actually being false. So even where we think we know where we should be looking, it's useful to review the algorithm in its entirety, because sometimes we pick up issues in other parts of it. Yeah, and this is something I think businesses should be thinking about as well, is regularly reviewing their code, not from the perspective of, I guess, the core business requirements, but also from the perspective of whether this is actually compliant with regulations.
And then, again, this will need answering in a general way rather than specific, I'm sure, but what I found interesting about this case was that the practices at issue were really visible, I mean, on the face of the advertisement, or on the face of the site, with the different availability of deals and the strike-through pricing and so forth. How does the agency, how do the data scientists go about thinking about those practices that may not be visible on the front of the site? And again, thinking about generalities rather than specifics.
That's a good question. I'm not sure how best to answer it. I think we just keep an open mind, like anyone working in investigations should. Critical thinking is about asking good questions. So when we're looking at code, we're constantly thinking about, well, why has this decision been made? Going back to that point I made about machine learning models, and I guess more generally all code being the product of decisions that someone has made, being aware that decisions have been made and thinking about why is really useful.
And then someone's wanted to get stuck into the acronyms here, but how are CPCs determined in these markets generally?
I think it depends. In this case, the CPCs were bid by the advertisers, so the advertisers determine what the bid amount should be. Yeah.
And again, a slightly broad question. I mean, some of the approaches here, I think, are akin to mystery shopping in a digital world. I mean, to take your example of picking an individual consumer and kind of walking through the journey they take. Mm-hmm. What are the limitations of those mystery shopping approaches on the internet of 2022?
That's a very topical question. I think that so there's a difference between, I guess, gathering information in a kind of covert way, in a mystery shopping way, that we might see with something like a web scraping approach, and gathering information using our compulsory information gathering powers, where we are going to the trader and asking them specifically for information. Concerns about the admissibility of mystery shopping evidence potentially apply to that first category that I talked about, but not to information that's gathered using legal compulsion mechanisms.
Great, thank you. So I think we're going to move to a coffee break now. For those online, the next session starts at 10:55 sharp. And with that, I'd like to just say thanks very much to Sally for the great presentation and answering questions.